guys! Welcome to Law Diaries Lex Comentario. So for today's video, we are going to talk about Article 47 of the RPC. Please excuse the mga chickens. So let us first read the provision of Article 47. Article 47, in what cases the death penalty shall not be imposed. Automatic review of death penalty cases. The death penalty shall be imposed in all cases in which it must be imposed under existing laws, except when the guilty person is below 18 years of age at the time of the commission of the crime or is more than 70 years of age, or when upon appeal or automatic review of the case by the Supreme Court, the required majority vote is not obtained for the imposition of the death penalty, in which cases the penalty shall be reclusion perpetua. In all cases where the death penalty is imposed by the trial court, the records shall be forwarded to the Supreme Court for automatic review and judgment of the court in banc within 20 days, but not earlier than 15 days after promulgation of the judgment or notice of denial of any motion for new trial or reconsideration. The transcript shall also be forwarded within 10 days after the filing thereof by the stenographic reporter as amended by RA 7659. So this provision, guys, is already considered as smooth and academic insofar as death penalty is concerned. However, the same procedure will govern for those who are penalized with reclusion perpetua. But for the purpose of understanding this provision, so ginawa ko tong video na to. Now, let's start first sa question kung justifiable ba yung imposition ng death penalty. According to the case of People versus Carello, social defense and exemplarity justify the penalty of death. Carello has proved himself to be a dangerous enemy of society. The death penalty imposed upon him is a warning to others. So sabi dito, guys, social defense and exemplarity will justify the imposition of death penalty. So when we say social defense, di ba? If ang isang tao is dangerous siya sa society, so in order to protect the society and the people and Cameroons, so kailangan i-impose yung death penalty. And exemplarity.
So, exemplarity here means set, paano ko ba explain?
Set as an example. So, for example, so there is one person na dangerous siya sa society. So, kapag i-impose yung death penalty sa kanya, so magiging example siya sa karamihan na hindi dapat tayo gumaya sa taong iyon para hindi tayo ma-tsugi. Ganun. So, yun yung exemplarity. And those two, social defense and exemplarity, yun yung justification kung bakit na-impose yung death penalty. So, is death penalty cruel or unusual? So, death penalty as such is not excessive, unjust, or cruel within the meaning of that word in the Constitution. Punishments are cruel when they involve torture or lingering death. Cruel punishment implies something inhuman and barbarous, something more than the mere extinguishment of life. This is cited in the case of People versus Marcos, citing the case of People versus Camano. So, yung explanation dito, guys, is hindi raw cruel and unusual yung death penalty. Kasi kung sasabihin natin cruel and unusual, it involves torture, yung dahan-dahan na pagkamatay ng isang tao. Pero yung death penalties kasi, tsugi ka, diretso. So, hindi siya cruel. So, yun yung sabi dito. So, hindi siya cruel, hindi siya unusual within the meaning of the Constitution. Kasi wala namang torture na nagaganap at diretso naman yung papatay. So, yung death penalty, according to the case that I mentioned, is hindi raw cruel and unusual. So, actually, itong provision na to, guys, is hindi na siya masyadong relevant during this time, diba? Kasi yung death penalty is nakasuspend siya.
So, parang Wala, explain pa rin natin. Go naman go.
So, the 1987 Constitution merely suspended the imposition of the death penalty. Section 19, Paragraph 1, Article 3 of the 1987 Constitution provides that excessive fines shall not be imposed nor cruel, degrading, or inhuman punishment inflicted. Neither shall the death penalty be imposed unless for compelling reasons involving heinous crimes. The Congress hereafter provides for it. Any death penalty already imposed shall be reduced to reclusion perpetua. A reading of said section will readily show that there is really nothing therein which expressly declares the abolition of the death penalty. The 1987 Constitution merely suspended the imposition of the death penalty. This is cited in the case of People versus Munoz. So, itong death penalty, guys, na-suspend lang siya, hindi siya na-abolish. So, meaning there's a possibility na pwede pa rin siyang mabalik. So, kayo, guys, ano ba sa tingin nyo? Kailangan ba ibalik yung death penalty or what? So, RA 7659 restored the death penalty while RA number 9346 prohibited the imposition of the death penalty. Ito si RA 7659, which took effect on December 31, 1993, restored the death penalty for certain heinous crimes. While ito namang si RA number 9346, which was enacted on June 24, 2006, prohibited the imposition of the death penalty and provided for the imposition of reclusion perpetua in lieu of death penalty. So, itong si RA, guys, 7659, binalik niya actually yung imposition ng death penalty, but then later on, ito namang si RA number 9346, prohibit niya yung pag-impose ng death penalty. So, instead na death penalty, yung ipataw na punishment sa'yo, yung ipapataw na lang is reclusion perpetua. Now, explain natin yung provision, diba? So, first, yung first sentence ng provision na to sa Article 47. It says here that the death penalty shall be imposed in all cases in which it must be imposed under the existing law. So, let's take the case of People versus Limaco as an example of that sentence in the provision. So, the accused without any provocation hacked to death 3 girls in their house. The court refused to impose the death penalty, believing and stating that a quick death would seem to be too sweet a medicine for him and he should be put to death slowly but surely, and impose life imprisonment and hard labor without hope whatsoever of any pardon or reprieve. Is the pronouncement of the court in accordance with law? The answer would be no. As long as the death penalty remains in the statute books, it is the duty of the judicial officers to respect and apply the law regardless of their private opinion. So, ito yung ibig sabihin ng the death penalty shall be imposed in all cases in which it must be imposed under the existing law. So, kapag nag-commit ang isang tao ng certain crime and then yung penalty niya is death penalty, regardless sa opinion ng judge, kung sasabihin niya, oy, wag na yung death penalty because napakadali naman ang punishment niya. Mamamatay lang siya agad-agad. So, dapat pahirapan muna. So, life imprisonment na lang. Keme-keme. So, hindi po pwede yon because the law provides death penalty as a punishment for that crime. So, dapat yun yung masusunod, hindi yung opinion ng judge. So, yun yung ibig sabihin ng first sentence dito. And then, dito rin sa first paragraph under Article 47, guys, it talks about the exemption in which hindi may impose yung death penalty. So, kahit yung isang crime na nakomit ng isang tao is punishable siya ng death penalty, merong mga instances or circumstances na mag-i-exempt sa isang tao na mag-render ng judgment ng death penalty. Therefore, death penalty shall not be imposed in the following cases. Number 1, when the guilty person is below 18 years of age at the time of the commission of the crime. Number 2, when the guilty person is more than 70 years of age. And number 3, when upon appeal or automatic review of the case by the Supreme Court, the vote of 8 members is not obtained for the imposition of death penalty. So, ito yung mga instances, guys, na mag-exam against sa isang tao na ma-tsugi siya. Ganun. So, yung first exemption, guys, is kapag yung guilty na tao is below 18 years of age. So, kapag ikaw nag-commit ka ng crime na punishable ng death penalty, and then you are only 17 years old, ganon. So, hindi may impose yung death penalty sa inyo because the law says so. Ganun. Number 2 naman na exemption, guys, if the guilty person is more than 70 years of age, so hindi na siya may impose ng tsugi-tsugi, ganun. So, hindi may impose yung death penalty sa kanya. Again, number 1, kapag yung guilty person is less than 18 years of age. Tapos, sa number 2 naman is kapag above 70 years of age na yung guilty na person. And then, the last one is kapag yung vote ng Supreme Court members are hindi na-obtain yung majority vote ng pag-impose ng death penalty. Kasi, yung majority vote ng Supreme Court is require siya para sa imposition ng death penalty. So, since the Supreme Court is composed of 15 members, so dapat 8 members ng Supreme Court mag-vote, ganun, na yes, i-impose natin is death penalty sa kanya, so ganun. Kapag hindi umabot ng 8 votes, so hindi mag-impose ng death penalty sa isang tao. So, in what cases is death penalty imposed? So, ano yung mga kaso kung saan mag-i-impose ng death penalties? Ang mga kaso na ito, guys, are charot. Number 1 is treason. Number 2 is piracy. 3 is qualified piracy. 4 is qualified bribery. 5 is parricide. 6 is murder. 7 is infanticide. 8 is kidnapping and serious illegal detention. 9 is robbery with homicide. 10 is destructive arson. 11 is rape with homicide. 12 is plunder. 13 is certain violations of the Dangerous Drugs Act. And 14 is carnapping. So, yun yung mga crimes na punishable ng death penalty. But again, yung death penalty na yan, guys, hindi na yan effective sa atin ngayon because suspended na nga, diba? But it doesn't mean na abolish na siya. So, may possibility pa rin na bumalik siya. Ganun. Instead of death penalty, yung magiging punishment is reclusion perpetua or 20 years and 1 day to 40 years. So, let us read this case, guys, because I think this is important. So, this is the case of People versus Bosa.
Please excuse the chickens and all.
So, the fact that there were no stenographic notes taken of the proceedings and that the lower court made only a brief reference to the plea of guilty in the decision did not speak well of the trial court's conduct in so serious a matter involving a human life. The essence of judicial review in capital offenses is that while society allows violent retribution for heinous crimes committed against it, it always must make certain that the blood of the innocent is not spilled or that the guilty are not made to suffer more than their just measure of the punishment and retribution. Ay, mga chicken. Thus, a sentence of death is valid only if it is susceptible of a fair and reasonable examination by this court. This, however, is impossible if no evidence of guilt was taken after a plea of guilty. This case, guys, it talks about that the trial court must require the prosecution to present evidence despite plea of guilty when the crime charge is punished with death. So, for example, ang isang tao, nakakommit siya ng crime which is punishable ng death penalty and then sabi na, yes, your honor, I commit it, ganun, I am guilty and all. So, hindi ibig sabihin na hindi na maghahanap ng evidence para ma-prove talaga yung guilt niya. It's because umamin naman siya na ginawa niya, ganun. Kasi, yung imposition ng death penalty, guys, capital punishment siya, diba? So, yung imposition niya is dapat serious talaga kasi parang minaliwala mo na lang yung evidence. It means that parang wala nang pakialam yung mga people of the world sa life ng isang tao. So, dapat talaga proof beyond reasonable doubt na ikaw talaga yung pumatay or keme-keme. Ikaw talaga yung gumawa ng crime na yon, which is punishable ng death penalty. Ganon-ganon. So, a plea of guilt would not suffice. So, dapat may evidence, strong evidence, ganon. So, I think this ends my discussion / book reading. So, thank you so much for watching, guys. Hope you learned something. Don't forget to like this video and subscribe to my channel. Bye-bye!
Bye-bye!